She has her order in council as a part-time Crown attorney. She practices primarily criminal defense work, but has also acted for the Law Society in prosecution and investigation of members who have run afoul of the Law Society. She has also represented lawyers and potential lawyers in admission, readmission, and discipline hearings. And it is a real pleasure to have Janet not only sitting with me, but I've had the occasion to work with Janet, and if there is any the word rising star is absolutely incredibly apt for this woman. She has accomplished a great deal in the short time that she's been at the bar, and there are still members of Convocation who talk about her address to full Convocation in the matter involving Harry Capito, where she acted with Frank Marrocco. And so I'm delighted that Janet is with me. On Janet's left is Brian Greenspan, great friend, partner in Greenspan Humphrey. Brian is the president of the Criminal Lawyers Association, and there's only one president. There are 3 vice presidents. And as I said about John Evans earlier, the job of running these organizations, John Evans and the Advocate Society have an executive director. The Criminal Lawyers Association doesn't. And the pressure that Brian is under and the job he's doing on behalf of the Criminal Lawyers Association is something that all of the 600 members are very proud of, and I don't think I need to talk about his incredible reputation before the bar. Brian has vast experience in appearing before committees of the Law Society and Convocation. To my far right is Dennis O'Connor QC. Dennis O'Connor is a bencher. He's a partner at Borden Elliott. Dennis has been very active, as you heard, in the changes at the Law Society. Dennis O'Connor has a vast background as a teacher, was a judge in the Northwest Territories, and if someone could be called the lawyer's lawyer, it's Dennis O'Connor. Next to Dennis is Frank Marrocco. Frank is now a partner at Smith Lyons, and formerly was at McFadden Marrocco Parker and a couple of other firms. One of which I was with, and Frank, of course, his reputation precedes him, articled with Arthur Maloney and has picked up the torch from Arthur Maloney and continues to practice in the criminal area, immigration area, and before the Law Society. His reputation as counsel for the Law Society, I'm sure you all know of. Of course, Frank now is busy filming Bambi 2, the sequel, and I'm sure we'll all hear more about that, and talking about controlling the press. And to my right is the person that you have heard a lot about this morning, and that's Gavin Mackenzie, Senior Counsel Discipline. And Gavin was formerly with Campbell Godfrey, represented many lawyers, also doctors, and had a very busy practice. And I echo the comments earlier, how grateful we are to have Gavin Mackenzie at the Law Society. Actually, he doesn't know this, but the reason that this program is called Open Windows, Changing Times, is because of Gavin. If I can just start off right away by calling on Gavin, and we have a script and we're going to move through it as best we can. We've got some lawyers who have gotten in trouble. That's where we are on this panel. And Gavin, can you talk about the discipline process and the changes that are going on right now?
Thank you very much, Bill. Let me start by saying that we have a script that will no doubt depart from time to time over the next hour or so. What I'd like to do over the next few minutes is describe the discipline process as it stands now, and then say a few words at the end about how we expect the discipline process to be changed presently as a result of the recommendations of the Keddy Committee on Discipline Reform. Now, I practiced before the Discipline Committee and Convocation very frequently over the last decade or so before I joined the Law Society on August 1st of last year. And I never really understood, and I never knew that I wasn't understanding how a lawyer came to be before the Discipline Committee until I arrived here. So I'd like to spend a few minutes just talking about internally what happens and what goes on before a lawyer receives a formal complaint of professional misconduct, which is a very traumatic experience, I assure you, and then what happens to that lawyer after that complaint's received. June Callwood was talking this morning about the number of complaints that are received by the Law Society, and that's the most typical way in which the process is initiated. As she was saying, we expect to have 5,000 complaints or so. They usually will come from clients more often than not. Sometimes they may come from other lawyers involved in transactions or litigation with the lawyer complained about. And at the Law Society, we've now separated the complaints function from the discipline function. And June spoke very accurately about the way in which the complaints are dealt with. The approach, certainly in respect of relatively minor matters, is to attempt to satisfy the complainant through a conciliation process rather than to try to resolve that complaint by laying a complaint of formal misconduct with the heavy hand of the discipline process before the discipline committee. If complaints reflect apparently fairly serious professional misconduct and require detailed investigation, they will be referred to what we now call the Audit and Investigation Branch of the Law Society. Traditionally, that's been known usually as the Audit Department, but its responsibilities really are expanded from what they were traditionally. The Audit Department, or the Audit and Investigation Branch, now includes a number of chartered accountants who get involved in investigations primarily of financial improprieties which are alleged. It also has on its staff, however, 4 lawyers, 2 of whom work as staff trustees. Their primary job is to see to it that the interests of clients are protected. If a lawyer is disbarred, suspended, retires, leaves the jurisdiction. Often they do that by arranging for another lawyer to take over the client so that the client's interests are protected. But 2 of the lawyers on the audit department staff are actively involved in investigations, usually about not financial matters, but legal improprieties, if I could characterize it in that way. And there are also 2 full-time investigators on the audit and investigation branch's staff. One of them is a former police officer. The other is a former employee of Air Canada who was involved in investigations when he carried on that function. Now, what they will do after they complete an investigation is that they'll provide my office with a counsel brief, which is in the form of somewhat similar to what a Crown attorney will get in a criminal case. It will include will say statements. It will include copies of all the relevant documents. We'll talk about disclosure later. Ultimately, however, that counsel brief will be produced in its entirety to the lawyer who comes before the discipline committee, if he or she does come before the discipline committee as part of the disclosure process. That's referred to my office, and either I or one of the 3 counsel who I work with will review that, formulate a recommendation as to whether a formal complaint of professional misconduct should be laid, if so, what the particulars will be, and that recommendation will go before the chair and the 2 vice chairs of the discipline committee at a monthly authorization meeting. Now, meetings are held monthly, usually on committee day. If there's a matter of considerable urgency, a complaint can be authorized. It's always in the form of a written recommendation, but it can be authorized more quickly in cases of urgency if there's evidently ongoing harm to clients. The recommendations, more often or not, that are made, I'm pleased to say, are accepted. After that, the formal complaint will be sworn. It will be filed in the office of the Secretary as required by the Law Society Act, and it will be served by registered mail on the solicitor who is charged with professional misconduct or conduct in becoming a barrister and solicitor. It will be served with a notice of a first appearance, which will be a date to set a date for the hearing itself. It will be served with some informative material, similar to what I'm telling you now about the discipline process, when hearings are held in camera, when they're heard in public, and that sort of thing. What will typically happen then is that the counsel who's acting for the Law Society who has sent out that material will receive a call from the lawyer or his or her client. They'll have a preliminary discussion about what is likely to be admitted, if anything, how long the hearing's going to be. The hearing itself is likely to take place, certainly after a disclosure meeting, sometimes after a pre-hearing conference before a bencher, similar to a court pretrial. And the hearing is likely to take place within a period of, say, 2 to 5 months after the complaint is sworn. We're able to get hearings on in this forum quite quickly because we have discipline committees sitting 3 weeks out of every 4, not for the entire week, but we'll have fixed hearing dates, usually the Tuesday and Wednesday of 3 weeks out of 4. The 4th will be convocation week, and discipline matters will be heard in convocation. So the hearing will take place before 3 benchers. Right now it may be 2 elected benchers and a lay bencher. It may be a former treasurer who is eligible to sit on the panel who is not currently an elected bencher. There's no current requirement that there must be a lay bencher in every case. That's going to happen soon. The hearings are relatively formal, as administrative tribunal hearings go, in the sense that the evidence is taken under oath. It's subject to cross-examination. As the Law Society's counsel, you open your case, you make submissions at the end of the case. The solicitor can testify if he wishes. He or she doesn't have to testify. And at the end of that process, if the committee is satisfied on the basis of clear and convincing evidence that a complaint of professional misconduct has been made out, they will make that finding and then hold a penalty hearing at which there may or may not be evidence as to penalty. It will often be character evidence led by the solicitor. They'll hear submissions as to penalty. And unless it's a relatively minor matter which the committee feels can be dealt with by way of a private reprimand or a reprimand in committee, they will make a recommendation as to penalty, which will be put before convocation at the next special discipline convocation. Special discipline convocations are typically held 9 times a year, once a month in every month except for July, August, and December, although that varies from time to time. More often than not, the only issue in convocation will be that of penalty, although it's not at all unusual for a solicitor to challenge the report of the committee and to make a submission that the report of the discipline committee, the finding of professional misconduct for one reason or another, should not be accepted. There's a right of appeal on the part of the solicitor to the divisional court. We tend to have relatively few. We haven't had any appeals in which I've appeared as counsel in the last year to the divisional court, but there are a few that you've probably seen reported in the Ontario reports over the last few years. You have a right as the solicitor to appear by counsel before convocation if you wish. So that's essentially the process as it is now. The principal changes which will be implemented as a result of the Discipline Reform Committee's recommendation, if they find favor with the government, will be firstly in the area of lay participation in the process. The Yaketi Committee's recommendations were that a layperson sit on the Authorization Committee, that a layperson sit on every discipline hearing panel, and that a layperson sit on the new Appeal Committee, which will replace the role of convocation as a whole in the process. That was one of the most controversial discussions that took place in convocation about the Yaketi Committee's report. There was a strong feeling among many benchers that convocation as a whole should continue to sit on discipline cases because of their importance to the work of the society. The other view was that convocation was spending a disproportionate amount of its time dealing with discipline cases. Convocation obviously has many other important functions, and the view that carried the day was that an appeal panel, which will consist of 7 benchers, 5 elected benchers, and 2 lay benchers, will hear appeals from discipline hearing panels. The discipline hearing panel in the reformed process will actually impose penalty rather than simply make a recommendation as the penalty, so that in a serious case, the 3 benchers, who will likely be 2 elected benchers and 1 layperson, will actually disbar the lawyer then and there. The lawyer will have a right of appeal and a right to apply for a stay of the disbarment order pending the hearing of the appeal. Now, a couple of other recommendations of the Yaketi Committee, which I might mention, are worthy of note. One has to do with the opening up of the process. The Law Society, of course, has come under a great deal of criticism for not being open enough about the discipline process, and the difficult balancing act, of course, that you have to do is to protect the right of a fair hearing on the part of a solicitor on the one hand, and to satisfy the public's need or right, if you want to put it that way, to be fairly and fully informed about what the self-governing profession is doing. Right now, what happens is that a press release will be issued which will describe the general type of complaint which has been laid against a lawyer, but will not identify the lawyer by name. Rather, will identify him or her only by reference to the geographical area in the province in which he or she practices. That will change if the Acadie Committee's recommendations find favor with the government. What will happen is that once a complaint is sworn and filed and served, that will become public information, so that if the Law Society receives a complaint, or an inquiry rather, as to whether a lawyer has been charged with professional misconduct, the inquirer will be entitled to find out that that lawyer has been charged, and will be entitled to receive a copy of the complaint itself and the particulars of the complaint. So that's one recommendation which has found favor with the committee and with convocation. We expect that will be implemented soon. And Bill, I've probably been talking far too long.
No, that's fine. Brian, concurrent proceedings. Client is charged with a criminal offense, and he also now faces a problem with the Law Society and Gavin. I'd like you to cover a couple of areas. Do you try and stop the Law Society proceeding? Do you use the Law Society proceedings to assist in the criminal case? How do you handle that situation? Does your client cooperate? Take it away.
A couple of observations. First of all, the question as to whether or not you can stop the Law Society is problematic in terms of just the process itself. And the Acadie Committee has essentially, in its Rule 17 recommendation, essentially formalized what happens to be the practice. And if I just might read it very, very briefly, the report indicates that where the facts giving rise to concurrent criminal charges and the Law Society authorized discipline complaint are similar and arise from the members' practice of law, your committee recommends that the policy of the Society should be to proceed with the discipline hearing expeditiously, subject to the discretion of the discipline hearing panel. Where the facts do not arise from the members' practice, but suggest conduct unbecoming a member, the Society may await the decision of the criminal court. Now, that appears to be the conventional wisdom right now, quite apart from the Acadie Committee's report, in terms of the way in which discipline wishes to handle the matter. And that is, if the criminal charge arises from the actual practice of law, then the committee wants to discipline expeditiously and perhaps bring the person before a hearing prior to the disposition of the criminal matter. I view that as being very dangerous, and although there's contrary opinion to it, I think it's a real problem in terms of the criminal charge for a variety of reasons. First of all, regardless of how serious the professional ramifications might be for the lawyer in terms of discipline, the criminal trial ramifications are clearly more serious in terms of ultimately of his liberty and his future. I prefer to test the matter in a criminal court and to have a preliminary hearing and full disclosure in terms of the criminal law process, to then pursue the matter very clearly on the standard of reasonable doubt, rather than perhaps the more ambiguous standard of clear and convincing evidence, although I think Gavin believes that to be virtually synonymous with reasonable doubt, but nevertheless a clear standard of reasonable doubt in the criminal trial. And then, if you lose the criminal trial, there may well be a surrender on the discipline matter. If you win the criminal trial, although that's not determinative necessarily of the discipline matter, it puts you in a very positive position in relation to what then must be done. I tend to prefer the idea of attempting to utilize a criminal transcript to cross-examine on the discipline proceedings rather than the antithesis of utilizing a discipline transcript to assist in the criminal process. I just think the risks are too high. However, the choice doesn't appear to be there. At least the choice isn't all that clear, because discipline clearly wants to proceed and wants to proceed expeditiously to supposedly protect the public. I find it difficult to understand how, if there is some sort of arrangement made with the Law Society to either restrict the practice of the lawyer charged, or to control or supervise the practice of the lawyer charged, or if necessary, to voluntarily suspend the practice of the lawyer charged pending the determination of the criminal charge, how the society can complain their duty to the public to protect the public from this person pending the criminal prosecution or pending the disposition of a discipline complaint can be met by control and supervision, and yet at the same time without prejudicing the possibility of the person's criminal trial being in somehow affected by the discipline matter. I also think there may well be, and I know that this is now being raised for the first time, there may well be a Starr and Holden issue in terms of concurrent discipline and criminal charges being a charter violation. There's no question that the Law Society can continue to investigate. The Law Society can continue to compile evidence and complete their investigation. But the report of that investigation, in similar terms to the dictates of the Supreme Court of Canada in Starr and Holden, that the report itself could not be released or provided until such time as the criminal charge has been heard. And I think that there's some parallels to draw and some analogy with Starr and Holden that might lead to the ability to stop or at least suspend a discipline hearing pending proper undertakings on the part of the lawyer pending the determination of criminal case.
Janet, do you see an area where you might want the discipline hearing to go ahead, despite the fact that there's criminal charges concurrently there? Is there any situations where you might feel like it's all right that the discipline matter go ahead?
Yes, in the case of perhaps a misappropriation which has a concurrent criminal charge as a theft, and you have issues of credibility that might enable you to establish that the theft is actually a miscast borrowing situation. If your client is particularly strong and is going to be testifying in both forums, I could see the discipline hearing process as giving you an opportunity, one, to tie down any witnesses who are going to be testing the credibility of your client ultimately criminally, and also perhaps informally to gain disclosure that will help you on the ultimate criminal proceeding. But also, if your client is accepted, if their version is accepted in front of the discipline committee, you may be able to be on stronger ground vis-a-vis the Crown to negotiate a withdrawal or some favorable position. The third advantage that I see is that having gone before the discipline committee first, you may be able to protect your client's reputation, because you may have grounds then to ask that the matter be heard in camera, keeping the evidence out of the public eye, because there's a pending criminal charge. And in that sense, you would have the best of both worlds. You would have, assuming all goes well, you'd have the discipline hearing without media scrutiny of the evidence, and then perhaps a favorable finding and either reduced misconduct or no misconduct found, and then perhaps the criminal charges would be out of the picture. In that case, the minimal amount of exposure to your client would be accomplished. The disadvantages and the conditions that might militate against dealing with it that way would be that you're giving the Crown disclosure of your position, and if your client does badly in front of the discipline committee, they may then be cross-examined at their criminal trial when they testify, and their previous evidence being used as to their credibility. So I can see cases where it would be helpful, but as Brian Greenspan mentioned, if the practice is that it's going to proceed expeditiously, the 2 to 5 month period mentioned by Gavin for getting before a discipline committee may not give you the choice anyway.
You should observe that it can sometimes backfire on the Law Society. And historically, I believe the first time that the Law Society proceeded with discipline before the criminal charge was a matter arising in Northern Ontario, where a lawyer charged with obstruct justice came before the Law Society, and Law Society wasn't impressed by the evidence, probably doubted that a criminal conviction would ever ultimately follow, and I believe suspended the lawyer for 3 months. He was promptly convicted by a jury of obstruct justice and sentenced to a period of incarceration. They were then faced with a lawyer who had been convicted of a serious offense involving the administration of justice, who they had already disciplined, and who had received a 3-month suspension. Perhaps to save face, it was only fortunate for the Law Society that he also had a significant fraud charge outstanding, and ultimately could be disbarred in relation to the subsequent matter.
Dennis O'Connor, what about sharing information with the police, and what about interdepartmental sharing of information within the Law Society?
Well, the issue that arises is when the Law Society's investigation turns up evidence that there's been a crime committed, or probably a crime committed or an offense under the Securities Act or something of that sort, and what the Law Society's position should be in terms of turning over the evidence or the product of its investigation. And the difficulty is that the Law Society has more coercive powers of investigation, or some might say more complete powers of investigation, than the police and some other investigators under other legislation. And for an example, as the situation now stands, the member who's being investigated, the member of the society, when confronted by the investigator and asked for explanations, is under, at least it's interpreted, a duty to cooperate with the investigation, and failure to do so may lead to a charge of professional misconduct. So that, good argument, it's not voluntary, there's a compulsion to answer questions. Police obviously don't have the same power. The current practice, which was adopted by Convocation a couple of years ago, was that the discretion as to whether or not to turn over the product of an investigation lies with the chair or vice chair of the discipline committee, and the test is whether or not it's in the public interest to do so. And the way I look at it, I start out the analysis saying, well, if there's evidence of a crime, obviously it's in the public interest that the evidence, at least at the threshold, be made available to the law enforcement agencies who would be appropriate. On the other hand, you have to balance that with the interests of the member who's being compelled beyond what would normally be the case. The proposals that have come out of the Reform Implementation Committee are that we should deal with this in a very specific, the investigatory powers and the duty of confidentiality of the Law Society and the turning over to other agencies in a very specific fashion. And there's going to be some, and I'll just do it very briefly, some rather significant changes. The proposals which have been adopted by Convocation provide for a broad access to the Society to obtain documents that a member may have in his or her practice. Starting with sort of an obligation to produce, right down to obtaining a search and seizure warrant from a court if necessary. They also require the member to furnish explanations to the society investigator with respect to the matters under investigation, and provide that the explanations so furnished are admissible in the Law Society proceedings against the member. This is founded on the notion that these proceedings are essentially regulatory, not penal, although, I mean, the member would certainly see the consequences of having a penal aspect. They go on to say that answers which are furnished as a result of the compulsion are not to be usable in any other proceeding, and under no circumstances are they to be turned over to other law enforcement agencies. I think there is some protection to be gleaned from that. The point on the other side can be made that if they are given in evidence at what is not an in-camera hearing before the Law Society Discipline Committee, that other law enforcement agencies, the police in particular, could become aware of those explanations, although they would not in themselves be admissible. In terms of the other product of the Law Society investigation, the proposals would move the discretion from the chairman of the discipline committee and require an application to a judge of the general division, at which the member who is being investigated, unless there is exceptional circumstances, would be given notice and an opportunity to make submissions. The proposals, you probably guessed, recognize that there are quite intrusive powers that the Law Society would be provided with. It's seen that that's necessary in order to fulfill our mandate of protecting the public, protecting clients' interests, regulating the profession. On the other hand, we're trying to balance that with the protection of the members' interests so that it's not too broadly used beyond what our internal purposes are. Oops. I suppose as a comment, I think we have to be aware that the public would expect, and it's a hard thing to balance, that when we know, if the Law Society does know or has solid evidence of the commission of crime, the public might fairly ask the question, why not always make it available to the police? And it's really a balancing exercise.
Dennis, what about the fact that we self-insure? What about interdepartmental sharing of information?
Well, the policy is that the insurance, the E&O, does make available when a member reports something that may be professional misconduct. The policy is that should be made available to the discipline committee, or to the discipline department for investigation. That is clearly a different situation than if our insurance was through a private insurer. Having made the decision, however, to be a self-insurer, the policy simply is that if we become aware of evidence that may give rise to professional misconduct, there should be an investigation.
So, Janet, do you take the position then that disclosure to the Law Society probably means disclosure to all departments in the Law Society and probably to the police?
Yes, I do. The rule that governs this has been referred to on the earlier panel in Rule 13, Commentary 1, and I spoke to Sue McCaffrey, who's the director of the Practice Advisory Service, and quite reasonably, their position is that as a department of the Law Society and being staffed by lawyers, they are governed by the rules. So if there is disclosure of misconduct to them, they're bound to report it to discipline. But having said that, different areas within the Law Society will have different philosophies, slightly different philosophies as to how they handle the matters in practice. For instance, practice advisory being there for lawyers to ask questions and to get help with difficulties. They do not view themselves as an arm of discipline in that sense, and as a result will not refuse calls from people who are reluctant, for instance, to identify themselves and want to talk about matters that are sensitive or perhaps have issues with respect to addictions and want referrals on to link. So that as counsel for a lawyer who is going to be making a disclosure to a branch or an arm of the Law Society, yes, I do take that position.
Okay, Frank, before I ask you about the charter, Gavin, do you have any comments about in this area?
Yes, I do. Just briefly on this issue of disclosure to law enforcement agencies is one that's given me a great deal of trouble over the last few months. And I just thought I might make an observation about what my perception is of what the chair and the vice chairs of the discipline committee do in practice when that issue arises, and give you one brief illustration of the problem. We as the Law Society do not as a rule release statements from solicitors which are given either in the form of a letter in response to a complaint, or in the form of an agreed statement of facts, or in the form of a statement which is taken by an investigator. We will not give those to the police. And that's certainly my perception of the way in which the chair and the vice chair of the discipline committee exercise their discretion when they're called upon to make a decision as to whether evidence should be released to the police. If the investigation reveals serious misconduct which may well be criminal, and we're in possession of real evidence of that, and certainly if we have a request from the police or the law enforcement agency that real evidence be produced, my perception is that they tend to exercise their discretion in favor of providing that information to the law enforcement agency just as a part of the Law Society's public duty. Now, one case that caused considerable concern on my part was a case that arose a few months ago where there were contemporaneous criminal proceedings and professional misconduct proceedings, where I was served with a search warrant by the police requiring me to produce a particular letter which had been written by a lawyer in response to a complaint. And the lawyer, in my view, was perfectly entitled to say in those circumstances that the letter was written, the statement that he gave was made under compulsion, in the sense that he might well have been charged with professional misconduct for failing to cooperate with the Law Society or for breaching his duty to reply promptly to communications from the Law Society if he didn't write the letter. Now, it was an exculpatory statement, but it certainly would have been awfully useful to a Crown attorney who was prosecuting this lawyer for a criminal offense. And the recommendation I made in that case was that the chair and the vice chairs of the discipline committee direct me to bring an application to the court for directions as to what to do in that case. And as I expected, once that application for directions was brought, the Solicitor's Counsel, who was also acting for him in the related criminal proceedings, brought an application to quash the search warrant. And it hasn't been resolved yet. It's been adjourned sine die, and it may or may not have to come before the court again. There's a case in the Federal Court of Appeal, a fairly recent decision, I think dated last November, called Tyler versus Minister of National Revenue, which deals with an analogous situation where a taxpayer was compelled under the Income Tax Act to give a statement to the income tax authorities. And it was a case where, again, there were contemporaneous criminal proceedings involving a drug transaction which was being investigated by the RCMP and prosecuted by the Department of Justice. And in that case, the Federal Court of Appeal reversed the decision of the trial division and held that it was a breach of the taxpayer accused Section 7 charter rights to require the taxpayer to give up that statement, or to require the tax authorities to give up that statement to the prosecutors in the criminal case. So that may well be of relevance if the issue specifically related to the Law Society's procedures is raised in future.
Mr. Chairman, Earl Levy wanted me to mention, if the occasion arose, and it just has, that Mr. Mackenzie's remarks, as usual, are compassionate, insightful, and decent, and that we all should be honored to sit in the same panel as him.
Frank was sitting there patiently.
Brian and I have a case coming up together, as you probably gather.
What about the charter, Frank? Does the charter relate to Law Society procedures?
Well, I think generally the view is that Section 7 does apply to the Society in its dealings with its members. There is alive in the air an argument that the right to practice law is an economic right and somehow not protected, but that view, I think, is certainly not held by the Society itself, and I don't believe it's correct. So I think you'll find that in dealing with the Society that the client has every right to assume that Section 7 applies. Obviously, the search and seizure provisions in Section 8 also apply. The only area where it's probably clear that Section 11 probably doesn't, because of the RCMP have already gone to the Supreme Court of Canada with their disciplinary proceedings and have been told that Section 11 doesn't apply to those proceedings. They never did ask the question of whether Section 7 applied, and so that issue was never decided when that RCMP discipline case went to the Supreme Court of Canada. So I think generally it does apply. I think one other thing you should consider, if you have clients who come to you and you perceive that they're being investigated by perhaps the Law Society and somebody else, whether it's a Securities Commission or police, it's not a good idea. It's important, I think, to formulate early on what's likely to happen and to make a realistic appraisal. And if you continue to allow the proceedings to fester, if the Law Society won't go away, won't stop its proceedings and wait, you have to recognize, I think, that the more investigative bodies you've got looking at the conduct you're concerned about, the more problems it is. And I think one of the great mistakes that's made is that an accurate assessment of the likely outcome of the Law Society proceedings isn't made early on. And if it's not going to work out well, then the person is best to start planning for a departure that's not going to prejudice the other problem, rather than creating a situation where you're dueling with two different bodies, both of whom have more resources than your client does, and both of whom will continue to investigate until they're satisfied. I think reference was made to some well-known cases earlier on, but I think, you know, you have to ask yourself when it becomes clear what the outcome of the Law Society proceedings are going to be, so clear that a person actually consents to their own disbarment, would they have been better off to come to that realization earlier and, in effect, written the Law Society out of the peace by ceasing to be a problem? And the more experience I have, the more I'm convinced that that type of decision has to be made early on, and that it's not good to drag it out.
I just wanted to add that to the
General tenor.
Before we move into the hearing and what happens in there, Frank, what about, I'm going to ask Dennis to comment on this too, but what about in-camera hearings? And
Well, I think we have to recognize, and I guess if you heard the first two panels, that as soon as you mention the word in camera today, everybody runs and hides. They don't want, the society itself, I think, doesn't want to be pilloried in the press for being a boys' club or a boys and girls club, and so proceedings are going to be held in public. If there's some sensitive medical information that relates to the complainant or perhaps to your client, then they may go in camera for that sort of purpose. If some sort of obvious prejudice can be demonstrated, then you can ask the committee to go in camera. The provision in the Law Society Act that says the proceedings are supposed to be in camera is generally viewed as being superseded by the Statutory Powers and Procedure Act provision, which says that administrative proceedings are generally to be in public. So you're stuck with a public proceeding, and I think it's just something you have to accept, that that's just the way it is.
And if we have some time, I'll come back to you later about controlling the press, but I want to move on a little bit. We're now at the hearing stage. Dennis, can you comment on the committees? How are they made up? Can I committee shop? Can I get away from you if you're on one of the committees, if I don't want to?
Wouldn't want to get away from me.
No, that's for sure. And can you make some comment about in-camera proceedings?
Well, Gavin touched on how the committees are made up now. There is no sort of restriction on how many lay benchers sit on a particular committee. Essentially, the people who are eligible to sit on committees are drawn from three pools: the elected benchers, the lay benchers, and the ex-treasurers. The proposals for change, as Gavin mentioned, will have a mandatory one lay bencher, and we're creating more lay involvement in the affairs of the society and adding or recommending at least that there be added 4 discipline lay benchers who would have discipline functions only. The reason for that is that the proposals for reform have a greater lay involvement in the discipline and complaints process, and we simply need more help from non-legally trained persons. In terms of the panel shopping, the Convocation established a couple of years ago a system whereby their panels are selected randomly by what equivalent of a trial coordinator, whose office is separate from the staff and the investigation office, so that there is absolutely, I'm satisfied it's the case, no influence from that side of the case as to who a panel will be. And similarly, there is no, I think, prospect for any influence from the other side of the case. And the actual selection process, to a very large extent, depends upon the availability of benchers. And a list is circulated from time to time. And while there's no minimum requirement on benchers as far as sitting on discipline panels, it is thought and hoped that benchers, when they have time, will all donate an appropriate amount of time to do it. But that is really a product of people's schedules, their commitments, and so on. One observation about it is that the workload in managing discipline hearings from the elected benchers, from everybody's standpoint, I guess, has increased significantly in recent years with the advent of charter arguments and longer hearings and so on. And when there is a hearing, as some recently have been that are forecast to last 2 or 3 weeks, that is a significant commitment for people to make in terms of sitting there all day and conducting those hearings, so that if anything, it's really who's on a panel is to a large extent a product of that. One of the recommendations we've made in the reform is that some matters be handled by single bencher panels, single benchers. It's not a panel, which would deal with the rough equivalent of summary conviction matters, but the relatively minor matters, failure to file forms and so on. And this is designed to try to cut down the workload on benchers so that they can devote it to the more significant, serious discipline matters. Other steps are being taken to cut down the workload as well.
Can Gavin and I come to an agreement that we want a certain specialist on one of the committees, for instance?
One of the proposals, now I think you could do it informally, and one of the proposals is that we recognize the desirability in some cases of having a bencher on the panel who has an expertise in the area, taxation, securities, whatever, but only with consent would we have then the placing of such a bencher on a panel.
Okay, we're moving a little slow. Gavin, what kind of evidence do you call? What's the role of the prosecutor here? What kind of evidence do you put before the committee? You have an obligation to disclose. Is there an obligation on counsel representing the lawyer to disclose?
There are a number of questions there, obviously. I resist, and I'm probably wrong in doing so, the description of the Law Society's counsel as a prosecutor. And I think it really is just a matter of semantics, but that conjures up for me notions of aggressive American-style district attorneys who try to send shoplifters to the gallows and that sort of thing. But, I prefer to think of the function as that of being the Law Society's counsel. And it's a partisan role in some ways, but it's certainly much less of a partisan role than the role of the counsel to the solicitor, or the role of an accused person in the criminal process, or the role of either the plaintiff's counsel or the defendant's counsel in civil litigation. And we could follow that through, I suppose, to deal firstly with, or next with a specific question that Bill just put, but really apropos the comment that I just made on the question of disclosure. The Ikedi Committee guidelines or the Ikedi Committee report contains very specific provisions on disclosure, and they were very hotly debated on the Ikedi Committee because it really raised a question that was raised in other contexts as well, of whether the discipline process is more analogous to a criminal trial process or a civil trial process. My own view is that it really is neither. It's really unique, but this became the example because the lawyers who were on the committee, the benchers who were on the committee, whose backgrounds were in civil litigation, felt fairly strongly that this is not a criminal process, nobody's liberty is at stake. There should be equal and full obligations of disclosure on both the Law Society's counsel and on the Solicitor's counsel. And those who had criminal backgrounds primarily felt equally strongly, or perhaps more strongly, that there should be no obligation on a solicitor whose right to practice may be lost to produce documents or make statements or come forward with witnesses and evidence that might incriminate him or her. And generally the view that prevailed was the latter one in convocation. Convocation altered the recommendation of the Ikedi Committee in some regards in that direction. So the obligation on the Law Society's counsel is very full. I'm quite proud of the guidelines. They require the Law Society's counsel to make full disclosure of all documentary evidence, to make full disclosure of all witness statements, whether they help or hurt the Law Society's position, to produce will-say statements if there are no written signed statements from witnesses, to produce all experts' reports which are obtained whether they help or hurt, so the Law Society's counsel cannot bury an expert's report which is unfavorable, and that sort of thing. So there really is a very full obligation of disclosure on the Law Society's counsel. Now, the obligation on the Solicitor's counsel is very narrow. There essentially is no obligation of disclosure on the solicitor after the formal complaint of professional misconduct is authorized. There is an obligation during the investigation phase to answer questions put by investigators, to cooperate with the Law Society, to answer communications from the Law Society promptly. But once the formal complaint of professional misconduct is filed and served, that obligation of disclosure ends. The only exception has to do with experts' reports. If the solicitor obtains an expert's report and intends to call the expert as a witness at the hearing, he or she has to produce the expert's report 10 days before the hearing starts, so that the solicitor can't ambush the Law Society's counsel by calling a witness who has very technical evidence to give without producing an expert's report in advance. But the solicitor can bury an expert's report that's unfavorable in a way the Law Society's counsel cannot, because the only obligation is to produce an expert's report if you are going to call the witness, if you're acting for a solicitor.
Dennis, you have a comment?
No, he's making
Okay.
something.
Brian, if let's talk about a discipline committee. What evidence do you call? What are you looking for?
Let me, before I respond to it, let me just comment on what Gavin's just said about the no duty on the solicitor for the solicitor to disclose. To some extent, you don't have to disclose after the formal complaint because the Law Society has already received its disclosure through the duty to cooperate. So that largely the Law Society has its disclosure of the position of the solicitor through that duty that exists prior to the formal complaint. So that process shouldn't be construed to be quite parallel to the criminal process, where there is really no duty to respond nor any duty to make any statements to the investigating authorities, because here there is that duty, and then you can run with it after, or at least have it until such time as the formal complaint is issued. Coming back to your question, Bill, largely, and I think that we ought to recognize this, and I don't know statistically how accurate what I'm about to say might be, but it seems to me that a large number of Law Society complaints, discipline complaints, are resolved by what would in the criminal law be called guilty pleas. And essentially what is being fashioned is an agreed statement of fact, or something that is a tolerable agreed statement of fact where the Law Society feels that it accurately represents what the complaint is, and the solicitor is prepared to accept the responsibility for those facts that are admitted. That's a very important part of the process in terms of ultimately receiving a disposition from the discipline committee that the lawyer can live with in terms of whether it's a reprimand in committee or convocation or something more serious. But an agreed statement of fact eliminates essentially the need to call evidence, and eliminates, to the extent that agreement can be reached, eliminates the dispute. That's also very important even when there are disputed issues. And I think it's important to attempt to resolve as much as possible by way of agreement as is achievable. And the reason for that is, I think, a very practical matter that's already been raised. We're dealing with very busy benchers who already are making a significant commitment in terms of the time they're devoting to these hearings, and anything that can be seen to be effectively reducing that time commitment is going to be welcomed and is going to be appreciated. And from the position of the solicitor who's facing potential discipline, that appreciation can be very important in terms of the ultimate disposition, so that as far as possible one ought to agree. However, bottom line is there are going to be serious issues that can't be resolved, and then I think you conduct it very much in a manner parallel to a criminal trial, in the sense that you cross-examine vigorously those witnesses that are going to be advanced to prove the issue. You raise, I think it's very important to raise before the committee evidence of good character, evidence of testimonial trustworthiness, any evidence that might support the position of the solicitor in the solicitor's denial. And the place to do it is at the committee. It is too little too late to think that you can resurrect issues of fact before convocation. I think that you have to put the record in before the committee as best as possible, and make your arguments as forcefully as possible before the committee. And then whatever results from that, I think that you're likely going to be stuck with at least that result. And if anything, you might end up with something that's less favorable to you at convocation rather than more favorable to you at convocation.
Gavin, a comment?
Just very briefly, I just wanted to comment in response to what Brian has just said on the subject of agreed statements, that in this forum we're blessed with a very small and very capable defense bar, which tends to really get to the heart of the issue, and that's not only considerate to the benchers, but it's also good advocacy. But we have people like Brian and the other members of this panel and Charlie Mark and John Laskin who don't fight about silly little things about making approved signatures on documents that are really admitted and that sort of thing, and it really facilitates the whole process, and I think it redounds to the benefit of the solicitor when that happens, which isn't, of course, to say that they don't fight vigorously and very capably when there's a legitimate issue to fight about.
Janet, what about admission? Someone is trying to get in. Someone's finished their articles, not so much readmission, but admission. What kind of evidence do you call?
The hearing is fundamentally different because now, on behalf of your client, you are the person, although on the balance of probabilities, you're the person who has to make the case. And you're not talking about a specific incident, you're talking about the character of your client. And in DMP, which is a 2-year-old, one of the few written decisions of a committee dealing with an admissions case, the committee talked about what character is, and just reading from that decision, the committee said that character is that combination of qualities or features distinguishing one person from another. Good character connotes moral or ethical strength, distinguishable as an amalgam of virtuous or socially acceptable attributes or traits, which undoubtedly include, among others, integrity, candor, empathy, and honesty. Normally, when you're going before the committee with a person who has to go through an admissions hearing, they've done something in their past that's shown that they aren't a person with those attributes. And so you have the task of bringing out evidence that shows that person now is of good character or has rehabilitated themselves if it's a criminal act. So the focus is really going to be on your client. And I think it's one of the toughest things to do is to prepare someone, and it's like the movie Defending Your Life. That's really what the person's doing. And you have to go through everything that happened to them, both at the time of the conduct, and it may be very hard for them to face up to that, and that's one hurdle, but then showing how they've either changed or how that action is not the action of a person who's fundamentally bad or flawed, but a mistake made by a person who is otherwise of good character. So that evidence is crucial, the evidence of your client, and anything that you can get to support it by way of people in the profession, people outside the profession who perhaps have employed your client, psychiatric reports, if it's a result of a drug or alcohol addiction, fairly convincing evidence that the person has that under control, and evidence of people who are best qualified to talk about what your person is like. And I would include members of family and spouses. But critically, it's your client is going to make or break it.
Frank, what about readmission? Now, someone has been disbarred. Will you make some comments in relation to readmission? And can I ask you, when you go through the discipline process, do you have an eye on readmission down the line?
Well, as I was saying earlier, I think the initial decision you have to make if you have a problem or if you're advising someone who has a problem is what's the likely outcome. If the likely outcome is disbarment, then you want the disbarment to go in a way which, if readmission is ultimately the goal, which makes the readmission application as easy as possible. And so you, notwithstanding the fact that the person's going to be disbarred, you want as many mitigating circumstances in the discipline proceedings that lead to disbarment as possible, because you're going to use them again later on, or the client is going to use them later on. If there's been a criminal charge, a person has pleaded not guilty, they haven't been believed, then of course the requirement that somehow the person ought to show remorse for what they've done gets a little awkward, because the person has never said they did anything. They went through a trial and testified and they weren't believed. So it becomes a little awkward to come back 5 years later and say, I'm really sorry for what I said 5 years ago, I never did. I think the readmission hearing is a forward-looking kind of hearing. And so what you really want to do is, if disbarment is going to come about, plan for the readmission hearing by the way you conduct the disbarment proceedings. In the readmission hearing itself, try to show why the future there's not likely to be any recurrence of any discipline problems involving the individual, and that invariably means describing virtually everything the person has done since they were disbarred, and why the problems that were created previously are not likely to represent themselves. Readmission is a very real possibility, and you shouldn't discount it. And however pressured the client may feel today, these matters will pass, time will pass, and the problems will be put into a perspective. And the person may very well decide one day that they want to come back. And it's important to lay the groundwork for that early on. If you think you've got a chance of avoiding disbarment, then obviously you conduct yourself entirely differently.
Gavin, do I have to admit that I'm sorry if I pleaded not guilty to be readmitted? And are we going to relitigate the finding of guilt?
Well, my view on that is that it would be a violation of the presumption of innocence, in effect, to hold against a lawyer the fact that he or she insisted or took advantage, availed themselves of the right to plead not guilty and put the Crown to the proof of their case 5 years earlier in a criminal proceeding. I think that the starting point on a readmission application has to be, well, this is what the lawyer was disbarred for. Now, what's happened since? Is the lawyer able to show rehabilitation? And I've said frequently that I think lawyers believe in rehabilitation in a way that members of most other groups do not. On the other hand, I think it's very important that committees, admissions committees, who hear readmission applications be sure that the rehabilitation is real and that they ask for convincing evidence and independent evidence that's independent of the former solicitor just asserting that he or she feels sorry before they accept that a rehabilitation process has in fact effectively taken place.
Both you and Frank use the term 5 years. There's no magic in 5 years. I think we should be clear on that. I don't think anybody thinks about being readmitted unless 5 years have gone by, probably. But there's no magic in that figure. It's just being one that's used. Is that fair?
Yeah, it's quite interesting. I've looked recently at what other jurisdictions do, and in New Jersey, for example, I found out that disbarment is permanent. In the sand, and
they're such a backward state down there anyway.
Haven't disbarred anybody in 6 years.
They have a rule there that is almost universally followed. That in all misappropriation cases, the view is that lawyers should be disbarred. And since the High Court in New Jersey promulgated that rule, there has never been an exception. And as I say, the consequences are a lot more serious there because disbarment really is permanent. Other jurisdictions impose time limits. Ours does not. I think it would be very difficult in most cases before, say, 3 to 5 years or perhaps slightly more has gone by for a solicitor who has been disbarred for very serious professional misconduct to be readmitted. But there may be cases where it really is a case where a lawyer was, during a very temporary period of his or her life, acting uncharacteristically and can conclusively demonstrate, for example, on the basis of psychiatric evidence, that that's the case, that the public interest would be protected, nevertheless, if that person were readmitted.
All the disbarred lawyers from New Jersey practice in Arkansas.
When Frank's finished with Bambi, the whole judicial system in the United States is going to change anyway. But, Dennis, the last word to you. You're sitting there as a judge. What do you look for in relation to disbarment and whether someone gets another chance or whether they get in at all?
Well, I think the process, I agree with Brian, particularly, and I'll deal with the discipline, but I think it applies to the others. It's essentially a trial process dealing with the question of whether someone's guilty of professional misconduct, whatever. And the committee's looking to find the facts and will do so much like a court or another tribunal will do. I mean, there are really no great differences. I have had a background sitting in criminal court, and really, from a decision-making standpoint, I don't find any significant differences in finding the facts. 2 comments. I agree very strongly. I was going to make it if Brian hadn't. The sensitivity to shortening the proceedings, if you can, is very important. Secondly, it's important to read your panel. The benchers, and particularly with lay benchers on the panel, have varying background. It can be quite a difficult challenge for counsel if you have somebody who's very experienced, litigator, say, and then somebody who has very little experiences, whatever. But it is important, I think, beforehand to sit down and try to make an assessment as to what the panel's experience is and how you're going to handle that. And there will inevitably, and counsel know from other tribunals, be somebody, one or two, who are going to be more persuasive and play more of a leading role, and you should take that into consideration. Only other comment is the most difficult decisions, as pointed out, the benchers make has to do with the dispositions, the question of penalty. And there are wide ranges of views on that, because that's the area where the protection of the public interest, protection of clients comes into play. And I think it's fair to say there's a very large element of sort of subjective assessment in convocation, which, if the proposals go through, won't be doing it anymore. But so much so that we have cases, it's not uncommon, where we will have some benchers arguing for a disbarment in a particular case, and there'll be others who see it as an appropriate case for a 3 or 6 month suspension. There's a broad range there. I'm not sure what advice I can give to anybody about how to appear as counsel before convocation. It is, and one of the reasons I support not having it as the final body is a most difficult body, I would have thought, to appear in front of potentially 40 or 50 people sitting in judgment. And it is difficult also to maintain uniformity, because you never know who will be there and who won't be there in any given day. I think, again, though, when one hears the debate in convocation, although views differ widely as to the result, those lawyers who often, such as Brian and Frank, appear before us and who are succinct, who deal with the facts, call their character evidence, and move the proceeding along, they're the most effective.
Just before I end, did we cover, there was some questions, I think we covered generally the questions you had, sir. Is that fair, or do you have, we only have a couple of minutes. Sorry? Sure, go ahead. We've only got a couple of minutes because the treasurer has some comments, but
I'll just be as brief as possible. I did pay $125 today, so I would like to get a few questions in. First of all, what are the rights of members who might be investigated, charged, and prosecuted by the society? Particularly, do the rules of natural justice apply, i.e., the right to know the charge and full particulars, and the right to confront the accuser, and the right to a full and fair hearing?
well, I think that we've basically covered that. I think the answers are yes, and you have the right to know what the evidence is that's being advanced against you. I think Mr. Marrocco has mentioned that the charter applies, and I think that we've kind of covered those areas.
Thank you. Further to that question, what is the extent to which disclosure is made to the member who is subject to such proceedings, i.e. investigation or prosecution?
Well, as Gavin has said, there's full disclosure now, and when I say now, that doesn't mean there wasn't full disclosure before, but I think that the Law Society is experiencing new times and new attitudes, and I don't think there's any difficulty with disclosure. I've certainly never experienced it, nor do I think any of the other members of the panel have.
Let me add to that. I think historically as well, as the criminal process has seen its obligation and its charter obligation to disclose more clearly and more precisely, so have all prosecutorial types of bodies, regardless of whether it's Law Society or other agencies. All of the agencies have now I think have almost a uniform policy of broad and full disclosure, including the Law Society.
Sir?
Yes, sir. If a member is subject of a complaint and pursuant to which the standard letter from the Law Society is issued requiring a reply within 10 days, is the member who is subject of that complaint entitled to know and be informed of the identity of the complainant? Are there instances where the identity of the complainant is not disclosed to the member who is subject of the complaint, and if so, please explain?
We don't know of any situations where the identity of the complainant would not be disclosed. I suppose if we sat here long enough, we could probably think of a situation, but I don't think that there's any situation where you would not know who the complainant is or could not find out.
Just one other area of question, Mr. Chairman, if I may. I just wanted to refer to, we've seen today and heard and read about the duties and responsibilities of members of the bar. I'd like to just focus here on the question of input about the rights of members. For example, a solicitor by the name of Dale from Peel County established that the Law Society exceeded its authority in the manner in which it conducted an investigation and perhaps also prosecution of this member, who was ultimately successful in recovering costs. So I'd like to just ask in that respect, what are the rights of a member to claim and recover damages if it can be shown that the Law Society exceeded its authority?
Brian?
I'm sorry, I had leaned over to Bill to indicate that the preamble, at least, was the subject of a full and thorough investigation by Chief Justice Parker, and that report is a public report and was made public. I'm sorry, in saying that, I think that I caused the chairman to miss your ultimate question because I was commenting on your preamble as opposed to your question, sir.
If I could just repeat that then, Mr. Greenspan and Mr. Trudell, what are the rights of a member to claim and recover damages if it can be shown that the Law Society exceeded its authority?
Gavin?
Well, I just wanted to point out that I don't know so much about damage claims. I don't know of any which have been asserted, but there is a provision in the Law Society Act for members to recover the costs of the proceedings if the proceedings are found to have been unwarranted. It hasn't been invoked very often, but there are 2 or 3 examples where requests of that nature have been made and they have been granted. I think essentially the test that seems to be applied in those cases is whether the society has made out a prima facie case. And where the society has made out a prima facie case, even though a complaint is ultimately dismissed, costs don't seem to be awarded. It's not like a civil process where the costs follow the event. But on the other hand, if there have been a case where the committee decides and ultimately convocation decides that there just wasn't a case there from the outset and no prima facie could be made out, there have been cases where costs have been awarded to a solicitor.
I want to thank you, sir. I
Could
think
I have one more question, please, Mr. Chairman?
last question.
Thank you. Just in response to what Mr. Mackenzie said, if the aggrieved member pursues a remedy for abuse of authority pursuant to the Law Society Act, for example, and has this matter placed before convocation or before a panel of benchers, and is then disappointed by the disposition there made, is that member precluded thereafter from proceeding to court for relief?
You mean, is the question, are there rights of appeal from a decision of a committee in convocation?
No. Can the member then bring a damage action instead of his Section 41 application?
Well, I think the member would probably want to seek legal advice on that one. I don't think that I would want to answer that question in general. But so anyway, we're going to have to close it down. I thank you for your
Thank you, Mr. Chairman.
interest. Ladies and gentlemen, I'd like to call upon the treasurer, and I want to thank you on behalf of all the members of this panel. I want to thank the panel. I know that a lot of work went into this program, and especially in this panel, I know that these people gave up their time and worked very hard, and I'm very grateful to them for coming, as to you. Mr. Spence.